So our next speaker is the Honorable Mark Dwyer. Judge Dwyer is a judge of the New York Court of Claims and an acting justice of the New York Supreme Court criminal term assigned to Manhattan. In his prior life, Judge Dwyer served as the head of the Appeals Bureau in the New York County DA's office, as well as counsel to the DA and Chief Assistant District Attorney. Judge Dwyer is currently co-chair of the New York State Justice Task Force and a former chief of the ABA's Criminal Standards Committee. Judge Dwyer.
And like Barry, I'm dressed in my Saturday presenter's outfit. I wonder how many blue blazers you're going to see here today. I've been doing this confessions talk for some time here, and usually I focus on the right to counsel, because New York's right to counsel is different from the federal right to counsel, and I suspect the right to counsel most any place else. But this year I want to start off a little bit by talking about another aspect of statements made by defendants, because there have been a few developments over the last couple of years that I think warrant a little bit of attention that way. I want to start with People against Dunbar, 24 New York. Well, the citations are in the outline. I won't bother to give them here. My part of the outline, my part of the material starts on page 36, and you'll see the various citations there. Dunbar was a case that addressed a very interesting practice by the Queen's DA's office that they thought was entirely legal and that they thought helped them get confessions. When a defendant was brought to ECAB, the Queen's DA would soften up the defendant a bit before giving him his Miranda warnings. And the kind of language that was used, which you can see in the Dunbar opinion, which is at page 49 to 50. The language that was used went something like this, and it was a script, so this was pretty much it in every case. The Assistant District Attorney described for Dunbar the charges he would be facing when he went to court, including the date, time, and place of the crimes alleged. The detective investigator then told Dunbar, "In a few minutes, I'm going to read you your rights. After that, you will be given an opportunity to explain what you did and what happened at that date, time, and place." Then came the preamble. "If you have an alibi, give me as much information as you can, including the names of any people you were with. If your version of what happened is different from what we've been told, this is your opportunity to tell us your story. If there is something you need us to investigate about this case, you have to tell us now so we can look into it. Even if you've already spoken to someone else, you do not have to talk to us. This will be your only opportunity to speak with us before you go to court on these charges." Now, the defense argument, naturally enough, was that the ADA was undercutting the Miranda rights even before giving them, just before giving them. The Court of Appeals agreed, and so those kind of softening up preambles are no longer permitted. And then we get to the Cpl Amendment that was passed this year. The Cpl Amendment calls for the videotaping of interrogations under certain circumstances. If you're talking about an A1 felony that is not a drug felony, if you're talking about a serious B violent felony in Article 125, the homicide article, or Article 130 of the penal law, the sex crimes article, the police cannot interrogate you at a detention facility, for example, a precinct, unless they record the statement that's made. And that way we'll know if any of these preambles are given in those cases. But it's important to note the limitations that the statute contains. And the statutory amendment is at page 57 of the materials. There are exceptions. If the machine's not working, if the machine is in use in another case, and so on and so forth, then the rule does not apply. In addition, if you do not videotape the interrogation, even without that kind of an excuse, it doesn't lead automatically to suppression. It is simply a factor for the court to consider. Well, why does it matter that we have these limitations on the videotaping? And I think you can get an idea from that from the Flores case and from other material that I'll read to you in a minute. The Flores case, which is, I'm already was so excited to get new materials to add. I think I made a mistake in the Flores citation, but it's not a major one. I think this is the case in which I wrongly said it was the second department when it was the first department. In any event, if you look at the Flores materials, not that I have them in the appendix, but here's what was said by an ADA on videotape, because this was an ADA recorded statement at ECAB. In a videotape statement to the prosecutor made several hours after the statements to the detective, defendant said, "I cannot pay for a lawyer. Why do I write yes or no next to the warning?" The prosecutor then said, "Do you understand if you can't," meaning afford an attorney, "the court will give you one?" And defendant responds, "So I put no." After the prosecutor reread the warnings, the defendant said, "Yes, I need to have a lawyer. I cannot pay a lawyer." The prosecutor said, "But do you understand that one will be provided if you cannot pay?" And defendant said, "Yeah, but I can't pay for a lawyer." And finally, the prosecutor told defendant, "Okay, so you can write yes if you understand and no if you don't understand." And defendant said, "Yes, I do understand." And then the defendant gave his statement. And the appellate court, of course, did not think that that was a proper way for the ADA to advise a defendant who was obviously confused about the right to counsel, about what his rights really were, and the statement was suppressed. And I've got something similar in one of my own cases, and it's an informal transcription by the defense attorney, but it's pretty accurate, and it's at pages 59 to 60 of the materials. This is a videotape statement by a police detective who's talking to a defendant who's accused of possessing a gun. He gives the rights, defendant understands, and then at the bottom of page 59, "All right, now that I've advised you of your rights, are you willing to answer questions?" "Yes, but I was going to ask you, like you said something about an attorney? Like I can have somebody that's an attorney sitting here? I don't understand. I've never been in one of these rooms like this." This is what is called Miranda Warnings, meaning, let me explain, meaning that this is not like, oh my gosh, I'm, signing my life away forever. This is just a notation, merely stating that, all right, I, Joshua Wright, I, Joshua Abreu. How do you pronounce that? Abreu. People pronounce it both ways. Now, how do you pronounce it? Abreu, both people pronounce it either. But I want to give you respect as a man. All right, Abreu. Okay, Abreu, you follow what I'm saying. I, Joshua Abreu, was read my Miranda warnings regarding as to, why I'm here. So it's just a notation as to, all right, you being advised of your rights as to why you're here. You understand? It's not like, So that's something you just have to read to everybody. Yes. All right. So it's not like you're singled out. You understand what I'm saying? So yeah, I'm willing to answer questions. Yes. Now, obviously, Mr. Abreu was left with no clue about what his right to counsel was. And had this not been a recorded statement at the precinct, no one would ever know about this, because the detective would have said, I gave him his rights, he said he understood all those rights, and that he was willing to talk to me without a lawyer present. That would have been it. Even the people have conceded that this one is no good, and that statement has to be suppressed. So, the bottom line is, it's important that these things be videotaped, or things like this would happen that we would never know about. You also want to make sure there's no coercion involved. You also want to make sure defendant doesn't invoke his right to counsel halfway through the statement. But just the basics about getting the Miranda waiver, it's so important to have those on video. And so the limitations in the new statute are extremely important. You will have police officers now who can legally take statements in C felonies involving violence and involving lots of potential prison time. When there is a video camera ready to be turned on, when nobody's using it for another case, but they can ignore the video camera and just take the statement the good old-fashioned way. So I think we all have to, I think it was a miracle we got the statute that we did. It was part of a compromise, and you'll hear more about that from Miriam Hibble when she talks. But for now, it's a very limited benefit to the defense, important in cases with extremely long potential sentences, but obviously it would be important in other cases as well. So let me now switch back to the right to counsel. And I want to start just by talking a little bit about indelibility, which is really what makes the right to counsel in New York special. Now, New York's right to counsel, as the outline indicates, it's based on very brief language in the state constitution. In any trial, in any court whatsoever, the party accused shall be allowed to appear and defend in person and with counsel as in civil actions. You will notice there's not a word in that right to counsel provision that has anything whatsoever to do with representation during statements made to the authorities before trial. But based on that thin reed, the New York Court of Appeals has, for better or for worse, created certain rights to counsel in those interrogation situations that cannot be waived. And that indelibility is a crucial aspect of it. If the defendant has the right to counsel, for one of the reasons I will get to in a short time, if the defendant has that right to counsel, he cannot say in most circumstances, hey, I don't want that lawyer. I want to talk to you now without my lawyer being present. He can't confess to the police, even if he wants to, unless his lawyer is present by his side. And again, for better or for worse, that's the New York rule. You can't waive the right to counsel in the absence of counsel. Now, there are a number of keys to when the right to counsel is triggered. But first, in this section, I want to talk a little bit about the exceptions to the right to counsel. And as a general matter, the right to counsel will survive indefinitely, but it can expire with the formal conclusion of the defendant's relationship with his attorney in the case, but not necessarily. Compare People against West with People against McLean. Okay, in People against West, we had a alleged big drug dealer who was wanted, I think, for homicide. And he was investigated. He got a lawyer for an appearance at a lineup, but there was not enough evidence, and so he was released. 3 years go by. The police decide they want to reopen the investigation. And so they get an undercover officer, and they send him to the basketball court where defendant is playing ball with his friends. And the undercover officer ultimately elicits statements from the defendant indicating his guilt in the homicide. The defense claims during the suppression proceedings, hey, you got my client to talk without his lawyer being present. And the people said he wasn't in custody. It was 3 years later. He didn't tell the undercover officer that he wanted a lawyer before he spoke to him. And so we should not consider that the right to counsel survives under those circumstances. And the Court of Appeals said no. Indelible means indelible. It's 3 years later, okay, but there is no indication whatsoever that the attorney-client relationship had been sundered. And indeed, at the suppression proceedings, the defendant was represented by the exact same attorney who had represented him at the lineup. And under those circumstances, the defendant could not speak to an undercover officer without his lawyer being present. It's a little different in McLean. In McLean, the police have the sense to ask the attorney, sir, do you still represent the defendant? And the attorney says no. And at that point, the police talk to the defendant, and that's okay. He waives his Miranda rights, he doesn't want an attorney, and there's no right to counsel violation because the relationship between the two had ended. One assumes, though of course it wasn't the factual situation in McLean, that it would be the same thing if you had said to defendant, gee, a while back you had an attorney named Smith who represented you on this matter. Does he still represent you? If defendant says no, presumably that's just like the lawyer saying no. But of course, in a case like West, they don't ask. In addition, if the attorney is dead, if he's retired, if he's left the jurisdiction, you presumably can infer that there is no longer an attorney-client relationship, but those things still have to be explored in the case law. And when we explore those things, it will be noted that the burden of proof is on the defendant to establish that he is still represented by the lawyer, and that's from the Court of Appeals case in Rosa. It's by a preponderance of the evidence, one presumes, but still it's the defendant's burden to establish that he and the lawyer still have a relationship. So one exception is that it may not last forever if the defendant or the lawyer disavows or ends the relationship. second exception to the indelibility of the right to counsel comes in emergencies. Now, the emergency exception, of course, Barry talked about it for the Fourth Amendment, but the emergency exception exists for the right to counsel also. And one of the weirdest fact scenarios you'll ever see comes in Crom. If you're a Conan fan, it's easy to remember the name Crom. If you're a Conan O'Brien fan, you have no clue what I'm talking about, but otherwise you may know what I'm talking about. In Crom, there was a obviously mentally unstable individual who was suspected of a kidnapping in which a young lady disappeared. And he talked to the police. He admitted sort of that he was kind of involved in all of this, and he said her husband was involved in the matter. And when he talked about all these things, he also had the right to counsel. I forget if he invoked it or if he had a lawyer already in the case or just what, but he had the right to counsel. He admitted under questioning that he had made 2 calls to the family asking for $1 million. He asked the police, what if I come down to $400,000? Would that be okay? And when the police didn't respond favorably, he said, well, about $300,000 then, and I'll give $100,000 to the husband. And the police didn't respond favorably. So he said, well, what if the family covers my attorney fees and my bail and my expenses? And the police again did not respond favorably. So ultimately, defendant admitted that he had been involved in the kidnapping, and he led the police to where he had put the victim in a kind of casket and kind of buried it. And unfortunately, the victim was deceased at that point. The defendant had been considerate enough to shoot rifle bullets through the top of the casket, hopefully to allow her to breathe, but he didn't plan it well enough. So the question then became, all of these statements by the defendant, are they going to be admissible despite the fact that he had a lawyer at the time he made them? And the Court of Appeals said, sure. You're trying to find a missing victim who may be dying, and in fact in this case was dying. We're not going to stand on niceties of right to counsel in that kind of a life and death situation. And so the statements could be used. Now, that makes perfect sense, although you could argue, hey, look, you can have the police ask those questions. You can't sue them for a civil rights violation. They can ask those questions, but it's a violation of the right to counsel, and you should still not be able to use them at the trial. You could say that. The Court of Appeals did not say that. They said it's fine to use these at trial, I guess basically on the assumption that if you're not going to deter police, quote, misconduct, unquote, with the suppression sanction, then there is no reason for the suppression sanction at all. And so those statements do come in. A little bit of a development in the same area in the Dahl case. In this case, the defendant not only had the right to counsel, but he had also invoked his Miranda warnings. But the police let a friend come in and talk to him with an investigator sitting right next to them. And the defendant made admissions to the friend that inculpated himself in the same kind of kidnapping scenario. It was another weird set of facts. The defendant was wandering at night in sort of a white jumpsuit, and he had wet blood on him. And he said he butchered deer in this outfit, but he couldn't explain why the blood was wet at the time. And it turned out eventually that even though the police didn't know for certain there had been a crime, there had indeed been a crime and indeed another fatality. Even though the police were not certain that there was a victim out there waiting to be found, it was okay for the police to trigger statements by the defendant because of the real possibility of an emergency. So the emergency exception doesn't apply only when the police are certain that there's a crime going on, but when it's pretty clear that something funny is going on that involves wet blood and therefore could certainly involve a victim. And finally, in this first section of my outline, appellate lawyers get no respect. And Colwell is a case that reinforces that. In Colwell, the defendant had a right to counsel on case A. The police wanted to talk to him about case B, and this is being decided at a time when they couldn't talk to him about case B because of the lawyer on case A. Except the defendant had been convicted on case A, and he had only an appellate lawyer, and the appellate lawyer doesn't count for this purpose. You can go ahead and talk to a defendant despite his appellate lawyer. Not that the appellate lawyer isn't interested in intervening on behalf of his client, but the appellate lawyer has his head in the clouds somewhere and has no concern about investigations that might be going on. Okay, now what are the triggers that create this indelible right to counsel in New York? And the first one of them is pretty simple. The filing of an accusatory instrument causes the right to counsel to attach indelibly. And that's clear from the Samuels case. Even a felony complaint, not to mention an indictment, even a felony complaint or any kind of a complaint, once filed in court, begins the criminal action and triggers the right to counsel. And so if you note in the CPL, the criminal action definition includes a requirement that there be an accusatory instrument. And the arrest warrant definition requires that there be a criminal action pending. And all that means that you can't get an arrest warrant until you file the criminal felony complaint or misdemeanor complaint or indictment. Well, why does that matter? It means that if police want to go out and arrest somebody in his home, they need an arrest warrant for patent reasons. They can't get an arrest warrant unless they file an accusatory instrument. If they file the accusatory instrument, they can't talk to the defendant after they arrest him in his home. And so it's kind of a dilemma for the police. They want to arrest the guy, and they want to talk to the guy. And it's dangerous if you get an arrest warrant because you can't talk to him. It's dangerous if you don't get an arrest warrant because you can't go into his home to arrest him at 6 in the morning with shields and dogs and things like that. So the police are nothing if not clever. They've come up with what you may have heard of, I-cards. I-cards are not a warrant. It's just an internal police force notification. We have probable cause to arrest John Smith. If you see John Smith, arrest him. That doesn't trigger the right to counsel because there's no accusatory instrument. It's legal from Fourth Amendment purposes because of the fellow officer rule that allows one officer to act on the directions of another officer. And so the police use this kind of an I-card, an arrest I-card, in order to arrest somebody. They still can't go into the apartment to do it, but they can do it anywhere else. And so they use the I-cards to bring people into custody. There are a couple other kinds of I-cards for witnesses and for people of interest, but the one for arrest is the key one here. And a little bit more on filing. If the defendant is accused in federal court, if there is an accusatory instrument filed in federal court, if there is an arrest warrant issued by federal court, even if it's the same general case as the state case, that doesn't count. This is the New York right to counsel. It's based on whether you've got a lawyer in New York, and your lawyer or your right to a lawyer in federal court simply will not matter to the New York courts. Well, what happens then if you arrest a defendant and you want to talk to him, but it's going slow? You know, if you file the accusatory instrument, if you take defendant in front of the arraignment judge, the right to counsel is going to attach, and you're not going to be able to finish questioning the defendant. So you slow things down. You lose the paperwork for a little while, or you just keep talking to the guy without filing the accusatory instrument. Does that violate the right to counsel? And the answer is no, because there is no accusatory instrument. The right to counsel has not attached. The delay under the Hopkins case could very well be relevant to voluntariness. Like if you talk to the guy for 6 days before taking him to court, it's more likely to be found an involuntary statement than if you bring him to court right away. But under Hopkins, you do not trigger the right to counsel with that kind of delay. So that's trigger number one, and perhaps the simplest of them. Trigger number two, a lawyer enters the case. Now, sometimes I've asked audiences, just as a generational divide indicator, who here knows who Perry Mason is? Who here does not know who Perry Mason is? I just see a couple, that's good. Who here knows who Detective Theo Kojak is? Who does not know who Detective Theo Kojak is? I see one or two. Obviously, Kojak is more impressive than Perry Mason, but the pilot for the Kojak show, Kojak, the guy with the lollipops who loves you, baby. Kojak pilot was based on a real New York case. I think in the pilot they called it the Wiley-Hoffert case. This one,
Marcus case.
pardon me?
It was called the Nelson Marcus case.
In Kojak it was, or was it?
Wiley Humphrey was the real case.
Wiley-Hoffert is the real one.
case.
See, not everybody has forgotten Kojak, that's good. In any event, it's a real case, and it was a tabloid-busting, headlines all over the place kind of case back in the day. These were two young career girls. In those days, a career girl was, of course, basically a secretary trying to make a business career instead of a family. These were two young, white, attractive ladies living in an apartment somewhere in Manhattan, and suddenly they were brutally murdered. And there was a manhunt, there was an investigation, everybody wanted to know what happened. And in Kojak, of course, Kojak got the confession, and Kojak got Marjo convicted, as I recall it. Well, the guy's name was really Robles, and back in 27 New York 2nd, the Court of Appeals said, look, we're going to affirm this case, even though the defendant had invoked the right to counsel, or I think even though the attorney entered the case. And then came the Hobson case just a few years later, and it overruled the Robles case. And Hobson is kind of the font of knowledge in this area, the basic case in this area, about counsel's entry in the case and the creation of the New York right to counsel. It was, I think, amazing that Judge Breitel, in discussing the Robles case, indicated that it had been gruesome, indicating, in fact, egregiously unnatural, and he used the term, quote, hard cases, unquote, obviously indicating that he thought hard cases make bad law. To see an appellate judge say that about one of his court's precedents from a couple of years before, I think is absolutely astonishing. I don't think I've ever seen anything like that otherwise. But the Court of Appeals was kind of embarrassed about three cases, one of them Robles, that called them three errant footsteps in the history of New York's right to counsel. And so Hobson reestablished the rule that once counsel has entered the case, you can't talk to the defendant anymore. Now, this had been the rule for quite some time before Robles and the other two, and Robles and the other two had indeed been three unusual cases in the line of New York right to counsel cases. But the ship was quickly righted in Hobson, and we resumed the rule that we've had before and since. Augustine emphasizes that this right to counsel is based on entry in the case rather than on assignment of a lawyer, like assign an 18B lawyer, but he hasn't shown up in the courtroom yet, hasn't met the defendant yet. That doesn't count. It's the entry of the attorney into the case that matters. And in this one, I really butchered the cite. So if you care, the actual citation is 8983rd 1238, and the cite I have there is a little variation from when the Court of Appeals affirmed it on other grounds. In any event, it's the entry and not the assignment that triggers the Hobson right to counsel. Now, what Hobson was talking about was exemplified, that is the prior rule before Robles, was exemplified in the Arthur case. And the Arthur case must have involved a one-horse town, or perhaps a one-precinct town, because the lawyer is sitting at home and he's watching the nightly news. And it comes on the nightly news that his client in a civil case has just been arrested in a criminal case. And so he puts on his coat, he runs down to the precinct, he knocks on the door, and he says, "I'm here to represent my client." And the police ignore him and keep talking to the client. And Arthur says, look, if the attorney shows up and enters the case, that's as good as if he enters the case in court. You can't talk to the client once the attorney is in the case that way. There are lots of variations on Arthur that come up over the years. In the Pinzon case, for example, it's not a one-precinct town. It's on Long Island somewhere. And Pinzon's lawyer calls police headquarters. He doesn't know what precinct the guy's in, doesn't even know what town the guy's in, but he calls the central police headquarters and says, "I represent the guy, don't talk to him." Now, the Court of Appeals says that that puts the police on notice of the representation, and the statements that were made after the call had been received are no good. In Carranza, however, the lawyer got the wrong police agency. He told the DA's office, don't talk to my client. He told the state police, don't talk to my client. But he didn't tell the local police, don't talk to my client. And it was the local police who were holding the guy. And the Court of Appeals says, too bad. You didn't put the right guys on notice of your representation, and so you did not enter the case. In the Grice case, I don't know if I'm pronouncing that correctly, but Grice, Dad showed up at the precinct and said, the lawyer is on the way. That's not good enough. It has to be the lawyer who shows up and enters the case. Dad can't enter the case on the lawyer's behalf. Okay, now Skinner is a case that says if the attorney is in, it does not matter whether the defendant is or is not in custody. So if you're talking to the defendant in a non-custodial situation and the lawyer walks up and says, I represent him, and then walks away, you can't talk to Skinner anymore, even though he's never been in custody. And once you arrest him, for example, you can't give him his Miranda rights and get a waiver because his attachment of the right to counsel based on entry of counsel is indelible. A couple of variations possible on Arthur. What if the attorney knocks on the precinct door and the defendant says, I don't want him? In Lennon, it was more than just I don't want him. In Lennon, the defendant said, he's represented me before. He's the scum of the earth. I never want to see that guy again. He does not represent me in this case. Well, the attorney's entry in that case does not count because the defendant did not think that she wanted anything to do with the defendant. But the same court in Bevilacqua, if I'm remembering the name correctly, the same court had a situation in which the family hired an attorney, sent him to the precinct without the defendant's knowledge. And the police said, hey, there's an attorney here who says he represents you. And defendant says, I don't know that guy. So the police keep talking to him. The second department in that case says that statement is no good. It's not like the defendant affirmatively said, I don't want the guy. And it's not like the attorney walked in off the street with nothing but his effort to gain a client behind it. Instead, this is the family. The family and the friends can send a guy, and you've got to do more than just find out that the defendant doesn't know that they're doing that. You've got to talk to the defendant then about the attorney, and they considered that the attorney had entered the case in that situation. So trigger number 2 was entry into the case by the lawyer. Trigger number 3 is an invocation of the right to counsel by the defendant. Now, the general rule is simple. If you are in custody and you invoke, the police cannot speak to you thereafter without a lawyer being present. And again, it doesn't matter if the defendant changes his mind because he's in custody and he's invoked. And Cunningham says so. You can contrast the Skinner situation, that where the attorney enters the case, it doesn't matter if the defendant is in custody at the time or not. But with invocation, it matters. You don't actually have a lawyer. If you are not in custody, you are free to change your mind, consult with anybody you want to. There's no pressure on you. When you are arrested, you can invoke your Miranda rights, but you don't have to. And so you can change your mind if you're out of custody and you've invoked. But once you're in custody and those pressures are being brought to bear, you can no longer change your mind. You've got to have the attorney there. In Ellis, the defendant said his attorney is on the way. That certainly counts as indicating that the defendant wants an attorney. It may not mean that the attorney has entered the case for the reasons we talked about just a couple of minutes ago, but it does mean that the defendant says he wants an attorney, and so you can't talk to him anymore after that. In Ellis, it was sort of an iffy situation about whether he was even in custody, but in any event, he invoked it and never changed his mind. I cite the Edwards case just because the federal constitutional rule seems pretty close on this one, and Edwards is what makes that statement. And these are basically factual questions about whether the defendant has invoked his right to counsel. You can imagine 1,000 different conversations in which the defendant mentions the word attorney, invoking or not invoking, depending on the little details of what he says. And I think there are two great places when you've got one of these cases and when you want to find out what the appellate courts have said about scenarios similar to yours. Two great places to go to find out what cases have been decided in the past. One is the Harris case, and in Harris, the defendant said, "I think I want to talk to a lawyer." And so you get other variations like that. And then you have Judge Brunetti's book on confessions, which he updates every year. And he's got a very long section detailing case after case after case with little parentheticals to indicate just what the defendant said that was or was not held to be an invocation. A couple of my favorite cases, there's a 2015 case in which the defendant said, "I want to talk to an assistant district attorney." That did not count. There was one just recently where the defendant said, "Yeah, probably," when asked if he wanted a lawyer. That did count. The police couldn't talk to him after that. But as you'll see, if you take a look at these parentheticals, there are just a million different ways that the defendant can either invoke or unsuccessfully try to invoke the right to counsel, and you'll have to look at the one that fits your scenario. Okay, now we get to the wild card. This is something that occupied much of my youth, I suspect much of Barry's youth, watching the ping pong ball go back and forth about whether representation on case A gives you a right to representation on case B as if you had the lawyer on case B. And we start on all of this with the Rogers case. Rogers says that if the defendant is in custody on case A and he's represented on case A, then he has the right to counsel and it's indelible just as much as he would in Hobson where he's represented on case B itself. So Rogers says that a lawyer is not going to abandon his client because the client is charged with a new crime, and so the right to counsel derivatively applies to new case B. Well, that was pretty simple for a defendant in custody. But Bartolomeo came along and kind of rocked the boat big time, and it said if the defendant has a lawyer on case A, but he's released and then commits crime B and gets arrested on crime B, you still can't talk to him because he was represented on case A. The derivative right to counsel applies whether the defendant is in custody or not at the time he's questioned, in custody on case A or not on the time he's questioned on case B. And again, in this scenario, the defendant was released on case A, he's in custody only because of case B. Now, that caused prosecutors all over the state to blow a gasket, and it led to incredible numbers of headaches for appellate lawyers. Because again, the scenarios differed dramatically, and especially the question always came up, well, what if the police don't know about case A? And what if the police pretend they don't know about case A? How do you find out factually what was in the police officer's mind when he gave the Miranda warnings on case B? And sometimes obviously it was going to be very easy to tell that the cop did know about case A. In other situations, it seems pretty clear the cop had no reason to know about case A. But in a lot of situations, it's kind of straddling the border, and you just got to make a factual finding about the cop's knowledge, which of course is not necessarily easy to do. There had been 9 years of litigation on these matters before Bing came along. Bing has a lengthy discussion of stare decisis, very interesting, and it basically says, look, Bartolomeo is not working. Nobody knows when they talk to the guy, or nobody knows in evaluating police questioning of the guy on case B, whether they should suppress or not. And so we are going to overrule Bartolomeo and not allow the derivative right to counsel where the defendant is rearrested on case B. Paquette was an entertaining variation on that. In Paquette, the defendant was arrested on a New Brooklyn case, Case B. He had an attorney in Manhattan. He'd been released on Case A in Manhattan. And the attorney was told about the new Case B. The attorney said, "I don't go over the bridge." And it was held that he did not represent defendant on new Case B. But in both of these cases, both Bing and Paquette, it's important to note that the custody is on Case B. Rogers, however, remains the rule where the defendant is in custody on Case A and then has been questioned about Case B. If you have that lawyer on Case A, you still have the derivative right to counsel on Case B if your custody is based on Case A. But that raises some more questions. Sometimes the defendant is in custody on Case A, but you don't know if he's got a lawyer. And in particular, in the Lopez case, the defendant was in custody in Pennsylvania. Now, he was being held in what looks like a pretrial facility, and so it was pretty clear, I think, that he was represented on the Pennsylvania case. The police talked to him about the New York case, and that didn't work. He was in custody on Case A. The police should have known about the representation on Case A, and the statement's no good. So there are also some more variations, though, that involve whether or not a bench warrant has issued. In cases that are in the outline, like Cohen and Napier, the defendant is arrested on Case A, he jumps bail, and he's being pursued as a fugitive. Cohen says that when he's arrested on the fugitive charge, that doesn't count as custody on Case A, and he can be asked about Case B. Why doesn't it count as custody on Case A, even though he was arrested after jumping bail? Because he's really being arrested on a fugitive charge and not on Case A itself. So his custody is not based on Case A, and you can talk to him about new Case B if you want to. And that happens in Napier as well, and there's another case, Brevard, in which it's true also. So the First Department certainly thinks that if you jump bail in New York and get arrested on a bench warrant, your right to counsel on Case A does not attach in new Case B. So again, you've got that Rogers right to counsel, but if you are rearrested on Case A, the fact that that custody looks like Case A custody doesn't count, at least in the First Department. It also matters whether you intertwine your questions. So if the defendant has a lawyer on Case A, but he's arrested on Case B, and you would expect under Bing that it's Case B that controls and there is no derivative right to counsel, you can mess it up if you're the interrogator by intertwining your questions with Case A. So if Case A and B are related, and you ask about Case A, and you ask about Case B, and then back to Case A, and then back to Case B, you may be tainting it because so much of the questioning was about the case on which he had a lawyer. And Irmo is an example of questioning that is an integrated whole. There were two attacks. Defendant was taken into custody on the second one, and the homicide had been earlier. The defendant is questioned about both the new case on which he had a right to counsel and on the homicide where he did not, but the attacks were similar, the questions were intertwined, and so the confession on the homicide turned out not to be good. In Cohen, there was a gun theft, and then the gun was possibly the one used in a later crime. The police could have done, said the Court of Appeals, a careful interrogation just about one or the other, but instead the police intertwined the two, which meant that the questioning, even on the case where he was not represented, would not be good. And again, you can see the relationship between the two. It's theoretically the same gun once it's stolen, once it's used, and for the police not to separate the questioning to limit itself to only the one on which there was no representation was fatal. In Silvagnoli, there was a brief and flippant, quote unquote, brief and flippant reference to defendant's narcotics charge on which he had a lawyer as the police were getting around to talking about the murder. But even though it was brief and flippant, it intertwined the questioning to the point where the confession to the murder was found invalid. The defendant had committed the murder at the same place where he had sold the drugs, and possibly, as the police put it, the motive for the murder was something connected to drugs. And so even the brief reference to the drug case was enough to taint what otherwise would have been a fine interrogation on the homicide charge. Rough is an example of where there was no exploitation, no intertwining. The defendant's in Florida. He's being charged with something down there. After talking to defendant about one case where he has the right to counsel, the police then get a polygraph operator to question defendant on a second case. And in the course of giving the polygraph statements, the defendant inculpates himself on the second case. The police had severed the interrogation into two parts. The interrogation with the polygraph expert did not involve at all any exploitation of the case on which he had the right to counsel, and so there was no problem with the confession in the Rough case. Now, we get to a few miscellaneous things that I want to mention before I wrap up. I've given you a list of lineup cases, not to talk about it any kind of length, but just to show what the right to counsel rules are with respect to lineups, and they're a little bit different. If there's a criminal action pending, you've got a right to have a lawyer at your lineup. If a lawyer has entered the case, you've got a right to have a lawyer at your lineup. If you invoke your right to counsel, it's more complicated. Invocation is not enough to get you a lawyer at your lineup unless you've got an attorney on another case. If you invoke by saying, I want my lawyer from the other case, the police have to bring that lawyer in to help you with the lineup. But if you are unrepresented by anybody and you just say, I want a lawyer, the police can say, tough, we'll do the lineup first, then we'll take you to court and you'll get your lawyer. In addition, a couple cases, in John P., there's an examination for Article 10 treatment. Now, Article 10, of course, is where we exercise preventive detention rights in New York. We think somebody is going to commit another sex crime, we can civilly commit him. And whatever the defendant says to the psychiatrist, he can't later try to suppress on right to counsel grounds. It's not a criminal case, it's a civil case. People Against Washington talks about chemical breath tests and your right to counsel after a drunk driving arrest. And it collects a lot of cases, and it also talks about the right to counsel at lineups. People versus Jabout, the defendant says, can I call my wife? And the court assumes that the wife might very well call a lawyer, but says, too bad. Invoking your right to marriage is not the same thing as invoking your right to an attorney. And I think that's about it. We've got a few minutes if anybody wants to ask me any questions or not. Yes, sir.
Well, wait for the mic. There's a mic coming down the aisle just as we speak. Right in front. This gentleman has a, down here. Just stand, raise your, yeah. I don't think it's on. Can you speak?
Hello?
Yeah, go ahead.
Regarding the right to counsel,
Speak into the mic.
you didn't mention the Dwyer Henry case that was rendered by the Health Division that's going to the Court of Appeals, in which the defendant was interviewed on two crimes, homicide and robbery, and they were related to each other. And I just want to know what your feelings are with that case, whether or not the Court of Appeals would affirm the conviction, reverse, continue with that reversal, or do you think that they would make a change in it?
I have to say that I don't know the facts of the case. I'm not sure if he had a lawyer on one case or the other, if he didn't vote.
Well, in that case, the defendant was arrested on a marijuana charge, and then they found in the vehicle also a stolen cell phone, and the investigation resulted in discovery that the cell phones were taken during armed robbery, in which masked men committed the robbery, and they drove away in a black Sonata. And then subsequently, there was a homicide and another case in a Citgo gas station, and the defendant again is
Yeah,
alleged to be.
I think that obviously that's a fact-sensitive case, and
Well,
it's,
the
Well,
thing
I
is-
think the bottom line is, if he's in custody on the marijuana case and perhaps even on the cell phone case, and he stays in custody on those cases, the police shouldn't talk to him about the homicide without his lawyer being present. If the appellate division said differently, I, of course, have to salute the appellate division every day when I get out of bed.
No, what
But
happened is,
I nonetheless think that they may be inconsistent with the right to counsel.
no, I thought it was interesting because it has involved with the police simultaneously questioning him on a robbery and a homicide, and he made confessions on both, and the appellate division reversed, and the people was granted leave to appeal. I just wanted you to know what your attitude.
Well, I think that's right. I think that if he was in custody on the robbery and had a lawyer on it, you couldn't ask him either about the robbery or about the homicide.
thank you very much, Judge Dwyer.